Good morning, everybody. My name is Farrell from HR Talk. It's my pleasure to introduce Gretchen Anker to you from Farrell Incorporated Attorneys. Gretchen is a senior associate at Farrell Incorporated Attorneys, and she'll be hosting the discussion this morning. She'll be dealing specifically with the following topics: retrenchments due to COVID-19, and whether consultations can be conducted virtually, as per the recent Labour Court judgment. Also, she'll be outlining the operations of retrenchment in cases of corporate insolvencies and liquidations. So a little bit about Gretchen is she's got a BA Law. She's frowning at me. Specializing in criminology, she's got an LLB, LLM in child law at University of Pretoria, and she's also facilitated numerous Section 189 and Section 189A, which is large-scale retrenchments, whilst she was employed at the dispute resolution, she was a dispute resolution specialist at NUMSA. She's also been involved in the Labour Court, so I think we're very privileged to have an expert with us this morning, and over to you, Gretchen.
Thank you so much, Joe. So I just start with my slideshow. Okay, guys, so just like what Joe said, what I'm going to discuss today is what is a retrenchment, how should retrenchments be conducted, what are the important retrenchment considerations during the COVID-19 and its effects on business. We naturally need to look at where do we find sources that guide us with retrenchments. So just as a little background, we have various sources. We have the Labour Relations Act, which is the most important source, Section 189 and 189 Big A, the Code of Good Practice for Dismissals based on operational requirements. Then we have the Basic Conditions of Employment Act, which is the notice period, and Section 41, which are your severance packages. Industry collective agreements, which basically comes in with MEIBC, MIPCO, your Road Freight Bargaining Council. They prescribe different things with regards to severance packages. And then we just have the common law as developed by decisions by the court. Very, very important why we treat retrenchments so with caution is because a retrenchment is a no-fault dismissal. So usually when you dismiss people, it's because of something that they did, conduct, misconduct, or that they're incapable of performing their job or anything like that. But a retrenchment is a no-fault dismissal. So that it places a larger onus on the employer to follow procedure and substance. And luckily, the LRA sets out exactly what you need to do in order to comply procedurally and substantively to the retrenchment procedures. The thing you'll see, I say it a lot in a lot of the slides, are that the consulting parties must attempt to reach consensus on various issues. Then the issues would be, as I said, set out in the LRA, but it's an attempt to reach consensus. It doesn't mean that the parties have to reach consensus, but you'll see it on a lot of my slides, and it's very, very important because that's just the nature of how retrenchment is done. It's a consultation process. The reasons that you embark on a retrenchment, Section 213 is your definitions in the Act, where, just so that you guys know, the LRA is the only Act with the definitions at the very back. All the other Acts have your definitions in Section 1. So the LRA is very, very special in that way. So Section 213 defines retrenchment, which is for economic, structural, technological, and similar needs of the employer. We can all agree that the nationwide lockdown has undoubtedly created fair reasons for a retrenchment. We have all seen the knock that various businesses have taken and still are actually taking. It's whether it be your gym or the bottle store not being open, or just, the curfews being implemented, the restaurants. And just, you need to remember that the onus will be on the employer to prove that a genuine operational requirement existed when you are contemplating retrenchment. For example, the employer cannot merely claim that the company was not making money and as such had to retrench employees. The employer will have to produce evidence of such a financial crisis. This basically comes in with when documents are requested by parties when you are in the consulting process. This will be discussed more in detail later. How do you start a retrenchment process? Well, you first need to ask yourself, is it going to how many people are you intending to retrench and how many people are in your company? The different sections of the LRA would apply. So for instance, if it's just a normal retrenchment, less than 10 employees, it's going to be a section 189. If it's a large retrenchment, it's going to be a section 189 big A. So the hard and fast rule that I always use, but you need to revert back to the LRA, is how many employees are you retrenching? If it's more than 10, it's a 189 big A. If it's less than 10, it's just a normal 189. So you start with giving a notice of anticipated retrenchment and an invitation to consult. And in this invitation to consult, you set out the requirements listed in section 189.3 of the LRA. You'll also see I refer a lot to the LRA. And as I said, the LRA has to be followed procedurally for retrenchment. So that is why I'm hammering on the LRA, the Labour Relations Act. This is what it's saying to us, okay? And then just again, the important reminder that a consultation process required by the LRA is a consensus-seeking process, not necessarily a consensus-reaching process. It specifies it in section 189. Okay, so in this 189.3 notice, it's a few things that you need to address. I'm just going to skip through it very quickly because it is it goes without saying. The reasons for the proposed dismissal, your alternatives that the employer considered before proposing the dismissal, and the reasons for rejecting each of those alternatives, the number of employees likely to be affected, the proposed method for selecting employees, this will also be discussed a bit later, a time when or the period during which the dismissals are likely to take effect, the severance pay proposed, any assistance that the employer proposes to offer the employees likely to be dismissed, the possibility of future employment of the employees who are dismissed, the number of employees employed by the employer, this comes in with section 189 big A, and then the number of employees that the employer has dismissed for reasons based on operational requirements in the preceding 12 months. So this is important. If you had embarked on a retrenchment, say you retrenched 2 people in the preceding 12 months, and now you intend to retrench another 8 people, this immediately makes it a section 189 big A. So you need to look at how many employees you have in total retrenched. And there are ways not to necessarily retrench an employee by offering voluntary severance packages or anything like that. I'll cover it later. So this is very important. That's why you need to look at alternatives to a retrenchment or alternatives that the employer had embarked on before embarking on the retrenchment process. It's just in the long run, you never know what might come. I mean, we did not foresee COVID-19 happening to us this year. So it's just, you always need to think what is coming in the future. So important to remember is the communication to the employee or the trade union must not be presented as a fait accompli. In other words, you must inform the employees that retrenchment is one of the options that you are contemplating, but that you are open to discussions and persuasion on their part. So the courts have held in various judgments that there's nothing wrong with an employer coming with a set outcome to the consultations, but you need to be open to be persuaded. So that's basically what it means. Don't come with a set outcome. Don't come and make as if you've already decided what you want to do. You as the owner of the business or as someone in one of the key positions in a business would know what needs to happen to help the business, but you need to be open for persuasion. And guys, I need to say to you, I have sat in retrenchment procedures where unions have actually come up with good ideas. So you lose nothing by listening. Okay, so with whom must the employer consult? In short, basically anyone that's going to be affected. So 189A sets out that any person that the employer is obliged to consult with in terms of the collective agreement. Okay, so now your collective agreement is your MIPCO, your MEIBC collective agreement, Restaurant Bargaining Council main agreement, Furniture Bargaining Council main agreement. If there is a collective agreement, a workplace forum, Okay, if there's no workplace forum, any registered trade union or its members likely to be affected. And then if there's no trade union, the employee is likely to be affected by the proposed dismissal or their representatives nominated for that purpose. So it's anyone likely to be affected. This includes minority unions, guys. So majority, minority, anyone likely to be affected. If you do not consult, it renders your consultation process defective and you stand to lose in the labour court or in the CCMA, whichever forum the matter might be referred to. Okay, so this is just a nice little case. Food and Allied Workers, FAWU, versus Cape Hospital Services. The court held that consultations with trade unions must take place where applicable, regardless of whether it is a majority trade union. So again, anyone, any person likely to be affected. How must the employer approach a consultation? Again, this is just another case law stating National Education, Health and Allied Workers, stating that you can come to the party or to the consultation with a set idea, but you must be open for ideas to be presented to you. So the Labour Appeal Court held that there is nothing wrong with an employer coming to the consultation table with a predisposition towards a particular method or of solving the problem, which has given rise to the contemplation of dismissals of employees for operational requirements. What is critical is that the employer should nevertheless be open to change its mind if persuasive arguments is presented to it. The employer should engage in a joint problem-solving exercise with the other consulting party or parties. When you now do consult, so just to give you practically how it would happen is you give the notice of anticipated retrenchment and the invitation to consult. So those are two documents, and then give it about 5 days. A reasonable time, and then when you physically sit and you speak to the workforce, you then discuss what is set out in your section 193 invitation, and also these the other alternatives that are set down here in section 1. So appropriate measures to avoid the dismissals, to minimize the number of dismissals, to change the timing, to mitigate the adverse effects, the method in selecting on the severance space. So I just want to say here, timing, employers are very strange sometimes. They embark on retrenchments at the very end of the year in order not to pay bonuses for whatever reason. Naturally, the company may or may not have made as much profit as they had thought, but this is, for instance, where the timing comes in. To mitigate the adverse effects, how can you try that it doesn't hit a whole family that's now maybe losing a breadwinner, okay? Severance pay, you can always discuss it. The Basic Conditions of Employment Act sets down the minimum, but you can always discuss paying a little bit more, okay? Method of selecting, I will discuss this more in detail, but usually you use LIFO, but you can discuss a different fare method. Okay, given the current restrictions and COVID-19, how must you meet to consult? Can you consult via Zoom, MS Teams? And we are lucky that the Labour Court recently was tasked to answer this question for us. So in FAWU versus SAB and another, FAWU in SAB embarked on a retrenchment process early in 2020 January. They asked, so basically it was going to be a large-scale retrenchment. I think they looked initially at a number of 500 employees to be retrenched. And then, so naturally it's a large-scale retrenchment. So then lockdown happened, COVID-19 and lockdown, and they asked the CCMA for assistance in proposing a way to continue with the consultations. And the CCMA actually said, why don't you guys use Zoom? So the employer says, yes, let's use Zoom. FAWU immediately jumps up and down and says, no, this renders the procedure defective because you need to consult physically. So FAWU approached the Labour Court to declare the virtual consultations procedurally unfair. So I always have a little giggle when I read this case because this case was heard on an urgent basis via Zoom. And so it's just funny because they're objecting to the Zoom consultations, but they have no problem having an urgent application heard in the Labour Court via Zoom. So basically the judge just said, listen guys, you do not need physical consultation. For you to be physically there does not make it any more effective or less effective. You need to consult. Nowhere in the Act does it prescribe that you have to be physically there. You just need to consult. So I just want to, yes, so any process that complies with Section 189 and 189A is bound to be procedurally fair. The Code of Good Practice issued in terms of the Act suggests that the consultation is regarded as proper if an opportunity to meet and report back to employees is provided, okay? The opportunity to meet with the employer is provided and the request, receipt of information and consideration thereof is provided. Consultation will be compliant when there is evidence of attempts to reach consensus on the appropriate measures, methods for selecting employees and severance pay. Physical attendance is not a requirement. So the court looked at Section 189. Then it looked at Section 188 in the Labour Relations Act, which it talks about unfair dismissals, and 188 then directs us to the Code of Good Practice dismissals for operational requirements, which basically just throws us back to 189. It's a little academic exercise that the court embarked on, but it was very well. It's a circle argument, which just brings us back to 189A does not say you need to be physically present to consult. You need to attempt to reach consensus, and if you can show that you actually listened to the other party, the union employees, then you did comply with Section 189, and it does not render the consultation process defective. Just a little tip here, if your employees gives you feedback verbally, the Act says you can reply in the manner and way that they propose suggestions. As an employer, I would say reply on paper, because then you have the paper trail to prove, where it's very easy to say, I didn't say something later on. Okay, so that's just a little tip. So what can we learn from this judgment? The LRA does not prescribe the form which the consultations must assume. Consultations need not be in person, and whether consultations may be held via Zoom or MS Teams depends on the facts of every case. Keep records of your consultations. Be able to prove it. Okay, so I put point number 3 in here because if it's someone that does not have access to Zoom or MS Teams, naturally you're not going to be able to do this. Okay, so each and every case would be different. If it's for instance, you're retrenching your domestic worker, nothing's stopping you from having the consultation maybe via WhatsApp or a telephone call, but have records of it, okay? After notice of consultation, employers must allow the employees to give feedback. That's what I keep on saying. Employers must afford employees the opportunity to make representations in relation to the proposed retrenchments, orally or in writing. Employers should respond within a reasonable time. 3 days, that's reasonable. If you can respond immediately, you can, but I've seen from practice that if you are able to respond immediately, it leaves the employees with an impression that you didn't think about it. Even though, yes, you might have prior to embarking on a retrenchment, but just go and think about it. You don't need to respond immediately. And then just again, keep records. Okay, so Section 189, Big A, I'm not going to read this whole slide. You can definitely find it in the Act. It just prescribes, like I said, my hard and fast rule is more than 10 employees, then it's a Big A. Yes, okay. Large-scale retrenchments, consideration. Okay, you do not have to have a large-scale retrenchment facilitated. Either party can trigger it by asking for it. It is better if you do, because it makes sure that you comply with the Labour Relations Act. The employer or the employees can compel the other to submit to facilitation by the CCMA or accredited agency during the consultation process. Section 189 versus Section 189 Big A, employees have a right to strike in an effort to dissuade the employee from retrenching. So that's our big problem here with 189 and 189 Big A. So it's not a problem. But in a Big A, the employees can, at the end of the consultation process, embark on a strike. You can then, as an employer, your right to recourse is a lockout. It's a closure lockout. the word escapes me now, but you can lock out as well. But this is the big thing. You need to, so the employees can go on strike, which if you're already a struggling business, you don't want them to go on strike. So basically facilitation is your best option. How do you request facilitation at the CCMA? It's an easy little process. You fill in a Form 720. At the first meeting, so they usually send you a commissioner, which usually they know everything what to do. They will explain the procedure to be followed, the date and time of additional facilitation meetings, and the information the employees are required to disclose. You must remember employees are required to disclose relevant information. So you don't need to disclose everything. If you're going to say, listen, we're retrenching due to structural or operational reasons, and it's not necessarily financial, meaning you bring in a machine to do the work of 7 people, then you don't need to disclose your financials. So you need to look at what's relevant. The process of a large-scale retrenchment notice in terms of 1893, everything starts the same. Notice and invitation to consult, then facilitation, and then your notice of termination. You must remember here that the consultation period must continue for a minimum of 60 days. So if it's a large scale, it's a 60 days minimum. You cannot do anything in the meantime. In that 60 days, you consult. If your consultation is done in 1 day, that's fine. But you can't dismiss and retrench before the 60 days. Okay. If a facilitator is appointed, the employer is not allowed to retrench for a period of 60 days. After 60 days, the employer can give notice to retrench, or the union may give notice to strike, or the union may refer a dispute concerning substantive fairness to the labour court. So the labour court cannot adjudicate over if the union says its procedure wasn't followed. Section 189.13 is the process, and you interdict for procedure not to be followed. The union can only refer to the labour court then after the 60 days for substance not being followed. There's no reason for the retrenchment. Okay. Why is consultation so important? So you might think, okay, I'm just going to go in there, I'm the employer, I make all the decisions, which is fine, and you are. I mean, it is your baby, you've built it for over years and years and years, but you need to consult, because if you go to labour court, you can get a very nice judgment against you of 24 months for each and every single person that you retrenched incorrectly. Okay? So in the first case here, the CCMA found that the employer had retrenched the employees for good and valid reasons, so substance was there, but still ordered the employee to pay each retrenched employee compensation because the consultation process had not taken place. Okay, and then there's a Toyota case. 280 employees were retrenched, and the court ordered Toyota to pay compensation to the amount of 15.2 million because Toyota had failed to disclose to the employees sufficient information necessary for effective consultation. There's nothing, I can't tell you what the other party needs for effective consultation. It is a case-by-case matter. So you need to look at it, and you need to try and put yourself in that person that's being retrenched shoes. Is it needed? Do I need further information in order to consult more effectively? Like I said, if it's for a structural reason, you maybe don't need to give the financials. But if it is for a financial reason, you might need to give financials. So for instance, if you are going to retrench, just a practical here, a sales manager, a director in the sales, and you're saying, no, we haven't been making target, our company is running at a loss. Now, this is someone in management and maybe a director. You are going to disclose financials because you're saying he is not, number one, reaching targets, so money isn't coming in, and the company is running at a loss. But now you just need to look here at the facts of that case, because it might actually be poor performance. So you should keep your processes separate. If it's poor performance, keep it poor performance. Don't try and push in a poor performance there in your retrenchment, because that does render your retrenchment procedure unfair for substance, and you will pay at the CCMA or at the labour you will. And that's also why it's very important to bring in consultants. They know the difference. Yeah. Then, what documents do I have to disclose? Again, relevance. Management accounts, rental agreements, exemption applications, any other relevant documentation. Exemption applications comes in with the bargaining council if you need to pay according to a certain wage, MIPCO, for instance, NUMWSA. You can apply for an exemption of that payment, of maybe leave enhancement or anything like that, and that is relevant documents. That naturally saves on your cost. So you need to disclose if you did embark on an exemption application for anything. And just a little one, you can ask for exemption on anything. So even after you've embarked on a retrenchment process, you can even ask for an exemption on certain payments after you retrenched. But remember, this is in the bargaining council, if it does provide for an exemption. I'm speaking mostly here towards the NUMSA. Alternatives to retrenchment worth considering. This is very important. You need to show that you did think before you went on your little retrenchment procedure. You need to see how can I increase productivity. So short time maybe, the duration and the shifts of the short time need to be clear. Rationalizing costs and expenditure. So I think it was the University of Pretoria. I was shocked when I heard their water and electricity account, but this was 10 years ago when I was there, which came to about R1 million a month. And so, okay, so there, for instance, maybe you can save some water or electricity by not leaving all the lights on in all the rooms. But that's, for instance, where you can look, where can I save some money? Decreasing the number of contractors or casual laborers. Using employees to perform the functions performed by contractors or casual laborers. So that's just bringing work in-house, okay? Outsourcing a function to its own staff after employees have formed themselves into a company. If employees do this, I've never in practicing or when I was a consultant, seen employees actually forming their own company. And I actually asked Dunstan yesterday if he has, and he himself has not seen it, but he has seen it almost happen. So this is I think this is a very nifty one, because it also makes entrepreneurs of employees. It gives them back their fighting spirit, I almost want to say. A retrenchment process, I just want to, it's not on the slide, but a retrenchment process is very emotional for a lot of people, and they don't know how to handle it. Especially, and I'm going to say especially to men, because they are historically known as our breadwinners. So if you can try and build a person up, I always think try and do that. And that's okay. So that's just my little emotional there. Voluntary retrenchment packages. Employees opt to be retrenched. The package should include an ex gratia amount. So you can give voluntary retrenchment package at any time. You can start your retrenchment by starting with a voluntary retrenchment package. The difference between a voluntary retrenchment package and just your normal retrenchment package is an ex gratia amount. Okay, so you just give a little extra to make the package look a little better. Okay, skills and development to enable employees to move into different positions. So again, you want to enable employees. You don't want to dissuade them. You want to still give them a fighting chance in life. I have another slide for voluntary retrenchment, and then I'll say there what I wanted to say. More alternatives is stopping overtime or Sunday work. So we all know overtime is 1.5 and Sunday work is 2 at the rate, meaning at the rate they were paid. So if you stop it, naturally you're going to bring down the bill. So stop that. Make your employees work during the time that they are at the factory or at the office or whatever. Okay, this naturally also depends on the nature of the business. If it is a business that works on orders coming in and orders having to be done immediately, and you can't really stop it, then you can't. But it depends instance to instance. Paying fewer workers overtime might be less costly than retaining a large number of workers and abolishing overtime. Bumping, I'll discuss bumping later. A lot of people do not know about bumping. I quite enjoy the concept of it. It's a bit vicious, but I quite enjoy it. Reducing wages. So if you reduce wages by agreement, it's allowed. But if you unilaterally say, I am now reducing, it's a unilateral change of terms and conditions, and you cannot. That is something, it's immediately going to go to the CCMA Labour Court. You can't do that. But by agreement, as an alternative to retrenchment, you can. Early retirement offers or schemes. So The NUMWSA's retirement age, early retirement age, I think is 50 years old. So if you have employees that are close to it, why not offer early retirement? It's better, those employees are tired, they don't want to work anymore. You then bring down immediately the amount of people that might need to be retrenched. Moratorium on hiring new employees, so that's just a big word for freezing the headcount. Gradual reduction of workforce by way of natural turnover, so again, you don't hire new people. Extended unpaid leave or temporary layoff. So this is just people stay on the books. Temporary layoff scheme is people just again stay on the books. And so a few years ago, the CCMA rolled out the temporary layoff scheme where employees were still on the books of the employer. The employer still paid the UIF contribution, but they went for little courses to learn new skills. This is a very nice way because if, for instance, after the whole period that was identified by the employer, if money-wise the business doesn't pick up or for any reason, that employee walks out with another skill that might enable them to engage better in the work, in the market. So again, it's empowering the employees. Okay. Voluntary separation packages. This case, NUMWSA, on behalf of members and others, the court said that, okay, so you need to look at a voluntary separation package. It is not seen as a dismissal, okay? It's a mutual agreement. It's not a dismissal. Somehow people see it as part of a retrenchment, part of a dismissal. It's the employee saying, yes, I want to go. So I'm tendering my it's not a resignation, guys. Please, I'm using that word, but it's not a resignation. But he wants to go. So he's taking the voluntary separation package. This does not add to the number of people that you are retrenching. So if you can, for instance, try and sidestep a retrenchment, why not? I had a case where, this was a few years ago, the company needed to retrench 10 people. I said to them, put out voluntary separation package. So it's the normal package plus a little extra. You make the deal a little sweeter. They needed to retrench 10 people. 10 people put their hands up. Company did not need to embark on a retrenchment. Immediately, the whole procedure it was just with one simple, let's quickly do this, and it helped. So look at it. Okay, bumping. Bumping can be vertical or horizontal, okay? Bumping is basically, it comes in where you have its LIFO counts as well. You use the principle of LIFO, last in, first out. So say, for instance, Doe and I are in the same company, but I have a little bit more years, or let's go, Doe has a little bit more years than me in the company, but I can do something more than him because now I'm an attorney, and Doe, are you an attorney? Mm-hmm. And Doe is not an attorney. So now, but he maybe has a senior position than me. I can come and say in consultations, bump Doe out of his position and I will take his position. So it's literally me saying I'm taking responsibility for letting someone else lose their job, either above me, so that's vertically, horizontally, if Doe and I are on the same level, and I'm the one being earmarked to be retrenched, and Doe is not, I say bump him out, and then again, that's then horizontal. So the reason I like this is because it's a little bit vicious, because you now are responsible for taking someone else's job, but a lot of people don't know about this, and a lot of people won't necessarily do it. But then again, when you are fighting for your job, you don't know. People show you a different side. So in the Porter Motor Group court case, the court held that both parties need to attempt to reach consensus again on alternative measures to retrenchment. In this regard, there is also a duty on the employee to raise bumping as a possible alternative. Okay. In this case, the employee was retrenched after declining a post office as an alternative, despite the fact that she could have bumped another employee who was getting paid slightly less than what she was earning. So you can also do bumping in order to save your job, but then you still get paid less. The employer had a duty to consult on possible bumping. Bumping uses the principle of LIFO as a departure point. Horizontal bumping should take place before vertical bumping. Bumping must be implemented with a minimum possible disruption for the employer. So bumping, I've It doesn't happen a lot. I've had one huge arbitration once over bumping, and it is a bit technical. So if you do sit with a bumping situation, get your consultant, get your attorney to assist you. Selection criteria. So in very short here life, last and first out. Okay, what selection criteria can be considered to be legally acceptable? Section 1897 says that 2 types of selection criteria. If you agree with the parties have agreed upon a fair and objective criteria during the consultation process, or no agreement. If no selection criteria has been agreed upon, the employer must prove he used a fair and objective criteria. The generally accepted selection criteria of the Code of Good Practice on operational requirements include LIFO, last and first out, the length of service, skills, and qualifications. So you just need to prove that it's fair. Okay, so if there's no agreement, if you and the union sit opposite one another at the table and you're discussing selection criteria and no one comes to an agreement, nothing, the employer just needs to prove that it's fair. Remember, you do not need to agree on your selection criteria. Okay, Singh versus Mondi, it's an agreed selection criteria, all fair and objective criteria, LIFO, skills retention, experience, qualification, combined approach. So you can have a little all-in-one there. If you would rather keep a guy that can work on 2 machines versus a guy that can work on 1 machine, why not? Okay, you just need to show that it's fair. Then, okay, so SAB versus Lowe took past performance into consideration. NUMSA versus Canapa Stainers had a combined approach. So there's court cases that do guide you in this, but again, selection criteria, use who you have. You're paying someone to assist you in things, use them. Severance pay requirements. Okay, Section 41 gives the minimum. So it's Basic Conditional Employment Act, 1 week per completed continuous year of service. And then Section 37 is your notice period in terms of the BCA, Basic Conditional Employment Act. You can pay in lieu of notice. Your collective agreements may prescribe something different. So, for instance, your Motor Industry Bargaining Council says for the first 4 years, it's 2 weeks per completed continuous year of service. NUMWSA says from 5 to 10 years, you get 1 extra week, 10 to 15, 2 extra weeks, 15 to 23 extra weeks. You need to look at your collective agreements. There's nothing that stops you from offering more for a Section 70, for your severance pay. Huge companies are able to offer 2 weeks per completed continuous year of service. So you can do that, okay. Then your notice period. Notices are given to employees who are to be retrenched after the consultation process has been completed. What does an employer have to pay? It's your severance pay, it's outstanding leave, it's your notice pay. If you are paying them instead of them having to work the notice, any other statutory or contractual payments, including pro rata or ex gratia payments. Pro rata bonus, for instance, okay? Pro rata payment towards contribution towards medical aid, anything like that. So that's what you need to pay. So it's your choice if you want your employee to work your notice pay or not. In an effort to assist them to get another opportunity, you would rather want to give them the time off and pay them in lieu of their notice so that they can go on a job-seeking adventure or go to all their onderhouden. Price Metal versus NUMSA and others. So now the question is, can an employer change shifts and move a few things around in order to save some money before embarking on a retrenchment? So Fry's, I just need to say, was decided before the amendments to the LRA. There's 2 court cases, so it's Fry's and Arbein. So Fry's is just basically the employees did not accept the changes and were dismissed for operational requirements. So the court held that the employers can dismiss for operational reasons, and these employees who do not accept proposals to amend terms and conditions of employment may find themselves fairly dismissed. So the alternative was, the facts here is just basically that Fry's, as an alternative to retrenchment, proposed changes to shift arrangements or anything like that. The court said that you as the employer still have a prerogative on how you run your business. So you can change the shifts, okay? That is well within your prerogative, and employees that do not want to follow the shift change, they can be then dismissed for operational requirements. So if you pose it as an alternative to a retrenchment, it works, okay? And naturally, again, you know where you need to save money. Okay, NUMSA being was decided after the amendments. Labour Court held that the proposal to alter job descriptions was an appropriate measure to aim to avoiding or minimising the number of dismissals, thus for a fair reason. The failure of the employees to accept the proposals engendered an insurmountable operational requirement problem that constituted a fair reason for dismissal. The employees don't want to follow your instruction, now you have some misconduct coming in. Okay, so then guys, just your SAA versus NUMSA matter that came out fairly, I think in this week or last week. Everyone knows what happened to SAA. It's a sad story, but basically business rescue. The business rescuers did not, they need to, in terms of section 136 of the Companies Act, put out their business rescue plan before doing anything. And they did not put out their business rescue plan to the union, but they embarked on a retrenchment. Then the union tried to stop this. They ran to court. SAA lost their court case. The Labour Court held that the business rescue practitioners had to put out the business rescue plan before embarking on a retrenchment process. And the court actually then, so this was also upheld in this most recent one that came out. I'm just making sure that they're now. The court held that naturally a business rescue is there to try and also save jobs where you can. Sadly, this is not the impression that the industry has of business rescue practitioners. I'm sorry if there are some of you out there that are listening to this, but it's more the norm that as soon as a business rescuer comes in, the company is basically done for. But the court held that business rescue is there to try and save jobs. There's no reason as to why the business rescue plan practitioners cannot unilaterally offer voluntary severance packages to the employees. So naturally here, voluntary severance packages was also offered. NUMSA fought this, and the court just said, no, you can definitely offer it. In closing, remember that retrenchments involves consultations. You consult about everything. It's a mutual consensus seeking process. The employees must keep an open mind when consulting. So you can come to the table with an already set out idea, which you would have because you know your business, but be open. Do not try and disguise another reason for dismissing an employee as a retrenchment, okay? Follow the procedure in the Labour Relations Act or face your consequences. Thank you.
Thank you, Gretchen, very much. We hope that was informative. We're going to take some questions. So if there are any questions, please type them. And what we can answer, we will answer. And what we can't answer, we'll come back to you. So please, if there's anybody that's on the webinar that would like to pose some questions to Gretchen, please go ahead.
Was it so informative? None of you have any questions? Yes.
Here we go.
Oh, we have questions.
So we have a question from Nuran Malik. He's asking, does physical attendance is not required? We understand that. However, does each employee have to be present with the Zoom consultation?
So if you have someone mandated to represent you, either your union representative, which would be through your shop steward and then your union representative, or if you don't have a union in the workplace and they chose one person to represent them, then not every single person needs to be in attendance in the Zoom consultation, no. But if every person says, I want to represent myself, then yes, they need to be there. But naturally, remember, if there's a union and they represent certain people, then the union rep would be the one representing.
And probably, Gretchen, if a dispute arises, the onus will be on the employer to have to prove that I made an attempt to consult with everybody, or there was a reason why that person was excluded either by accident or the representatives didn't represent him properly or something like that.
100% yes, yes. So if there is employees that have said, okay, we choose this person, we choose Gretchen, or we choose Doe to represent us in this consultation, have them do it on paper, like a little proxy. I give you the authority to represent me. Okay.
Thank you. Then we have a question from Vishal. Vishal is asking, in the current circumstances of COVID-19, can reduced working hours be implemented as an alternative to retrenchment?
Yes. Yes. It's basically, it comes down to short time. So yes, you can. You implement it, and it's, yeah, yes.
But again, the process of consultation needs to be followed. 100%.
Everything. Guys, I'm not saying consultation, but everything needs to be consulted about.
Okay. I hope we've answered that for you. Any other questions? There's a great question from Lindsay Rice. That's asking if there's only one person in a part of a union.
Does the union still need to be involved?
Do they still have to consult that union?
That union is then, well, minority of a minority, but yes, you have to. You still need to you need to inform all unions in the workplace that you are embarking. That union can then naturally say, listen, I'm not going to come and waste my time for one person, which I don't think would be the case. But yes, you have to. In Pretoria, we have, so remember, solidarity is very big in Pretoria. So you don't know people belong to solidarity unless they flash their card. So you always put that out and then you wait for it to happen. Solidarity might have one person in the workplace or two or whatever, but you need to, if you know solidarity is in the workplace, you consult with them.
Lindsay, just to also build on that, I had a very interesting restructuring discussion the other day with a client and a union, in which we had a restructuring process was presented to the employees, but we then realized that we had unionized and non-unionized employees. So we then made sure that the non-unionized employees were represented in the forum in which we discussed the restructuring exercise. So we called all of those employees together and said to them, either you guys can all join, but I mean, it was a huge organization, more than 50 employees, so it's impractical to do that with everybody. Or elect somebody that we will then almost like work with that person the same way as a union representative will work. And it worked really, really well. Those two guys then got together, so the unionized person and the non-unionized person got together, and they then presented a joint proposal to management to consider. So we just felt it was important to hear the voices of because you always assume that I need to deal with the union, but you also need to deal with the non-unionized employees in a way that's practical and that addresses your the concerns that the Act has for you to consult with everybody. Let's see if there's another question. There's a good question from Nuran. Does the retrenchment letter need to be presented to employees before the consultation process starts?
So you have your notice of intended retrenchment and notice of invitation to consult. So those have to, yes. Because otherwise, what are you going to talk about? You need to tell your employees what are you going to talk about. And a retrenchment doesn't happen, okay, now yes, it happens everywhere, but it's not a thing that people naturally walk into. So you give them the letter, the notice of anticipated retrenchment and invitation to consult, and in your invitation to consult, you have the section 1893 requirements set out, yes.
And then Vishal is asking, can you explain temporary layoffs in a bit more detail? I've lost it now. Oh, sorry, Michelle, didn't just grab it, it's just moved out of the way. Can you explain the temporary layoffs in a bit more detail, if possible, under what circumstances can it be implemented? So, Michelle, we do temporary layoffs as also as an alternative during Section 189 discussions. And it is something that we present as an alternative. So we have previously for clients that have come to us and said they don't want to retrench because they want to see what's going on for the future, and they want to present temporary layoffs. And we simply consult on it and we present it as an alternative. And so far, I've not had one instance where employees have rejected that as an alternative. The difficulty you have, though, is you can't have a temporary layoff in place for a lengthy period of time. Generally, what we prescribe to our clients is we advocate, say, 3 months, see how that goes, but at the end of that, you need to make some sort of a decision. It's unfair on the employee to expect that the employee to go for an indefinite period of time without any income, and the income coming from potentially the UIF only, or potentially they've run out of money from the UIF and have no income. I don't think the court's going to agree with you from a fairness perspective only, and that's the only angle that I have here, is that you have this in place, for example, to say for the next 6 months. I don't think the court's going to agree with that. It's a temporary measure. Buy you some time, see what's going to go on, unless you disagree with me, Gretchen. But I really feel that you need to make sure that you're fair with employees. The other thing that might happen during that layoff period is the employee might come back and resign, and then probably afterwards go to the CCMA and claim that they've been unfairly dismissed, and where's my retrenchment money? So I think you need to be very careful when you want to do it. That's why you've got people that does this kind of stuff for you. And of course, we consult with our attorneys as well to help us make sure that we do the right thing for our clients. I
just want to add here with the temporary layoff scheme, if you have a union, the union also negotiates the temporary layoff scheme. There's a little contract that you fill, you agree on, and you fill it. The CCMA has little requirements, because now remember, they're falling under the CCMA, and then there's a UIF payment and everything. So there is a contract that needs to be concluded by the union and the employer together, which needs to be submitted to the CCMA in order to fall under temporary layoff scheme now. So just remember that. That's also a very... The
CCMA has got a dedicated, for example, we know specifically in Durban, because we've dealt with that situation before, there's a specific layoff training person at the CCMA. I forgot, Urmila Patel is her name. I don't know if she's still there, but I dealt with her last year still. So she's dedicated to the layoff process at the CCMA. So if you make contact with them, they immediately come out. It's like a well-oiled machine. All the gears kick in, and they come and talk to the employees themselves. It's a very different kind of process as well. But it takes quite long to get into that process, because you need to get hold of the CCMA. So the CCMA is involved, but you need to get hold of the necessary CETA that's going to provide the funding. Have they got capacity to train? So it's quite an involved process to get that going. Then, Vishal, your other question is, does this require agreement as well? Well, again, to what Gretchen said earlier, you don't necessarily have to. You need to try and attempt to get agreement on this, but you don't necessarily have to. So you probably could, after lengthy consultations, implement it. But again, do it with care, and if you can, try and get agreement. Yeah, I've answered it. Any further questions? Oh, Lindsay, I see your chat. If you are doing a small retrenchment, and I'm reading the question for the benefit of the webinar. If you are doing a small retrenchment, less than 10 people, do you still have a 60-day consultation period?
No, you don't. But reasonable, hey? Just be reasonable about the whole situation. It is a shock to a guy or a girl when they are faced with these notices and everything. So less than 10 people, again, this is my hard and fast rule, but read the act. No, You don't have that 60-day waiting period, no. And then if something does go wrong with your retrenchment there, I just want to say that's CCMA jurisdiction. Big A is Labour Court jurisdiction.
Sometimes, sorry, I missed yours. Hello, do you follow a retrenchment procedure for businesses shutting down, operations winding up, or are those considered as two different concepts?
It's a retrenchment, operational requirements, business is shutting down. Look, here you are coming to the party with the fait accompli. Okay? The business is shutting down, you can't do anything about it. In those circumstances, the employees usually know what's going on. They're not going to put up a fight, they just want their severance package, their years of service. That's a very somber situation. But they know what's going on. Employees know. Guys, I just want to, sorry, I didn't mention it in my slides, but a very nice thing to remember is if you offer alternative employment and it's unreasonably refused, you do not need to pay a severance package, okay? But it needs to be a reasonable alternative, and if it's unreasonably refused. So just for instance, if you are in a factory area and you have a few factories doing the same thing and you can get employment for some of your employees at different factories and they unreasonably refuse it, then they forfeit their severance package. So that might help with a business closing down, okay?
Okay, and then CT asks, can you explain bumping requirements versus LIFO?
Okay, so LIFO is last in, first out. Bumping is basically, you look at LIFO, but then you say, I'm the one earmarked for being retrenched, okay? But I was here shorter than that other person. Don't just correct me if I am explaining anything wrong. But I was here shorter than the other person. And now I'm saying, bump that person that's not earmarked for retrenchment out of his position so that I can take it, even though I was just shorter. So remember, last in, first out, your period of time is shorter. Now you're taking someone else's job. So that's how it works. So bumping vertically and horizontally.
So, Nuran, you're asking again, a mention was made of a 60-day notice. So if employees are informed, say today, verbally does 60 days start from this date or from the date of the retrenchment letter is presented to the employee?
From the date that you gave them the notice of anticipated retrenchment and notice of invitation to consult.
Yeah.
Make it a hard and fast date. Don't go orally. You don't do that.
Yeah, I agree with that, Nuran. We don't ever we follow the one with the other. So we talk, but at the same time the formal letter is issued. Guys, we are slowly running out of time. We're in fact already out of time, but I quickly want to just grab a question here from Guy. Guy, you've asked, if you're retrenching one department, are you required to consult the whole company?
No, because it's not affected.
Yeah, I agree with that view, and although I might just say you might have to later on consult if the principle of bumping becomes an issue, that you might have to say to a person, you were not affected before, but now you are because bumping has become an issue that we need to consider. Then, Nuran, you're asking again if the severance package should be 1 week, whether the company decides to rather pay 4 weeks severance. So 4 weeks in lieu of notice still due to the employee?
Notice pay you have to pay. 1 week per complete continuous year of service is your severance pay. So you look at section 41 for your severance and you look at section 37 for your notice pay. So if that's notice, then that's notice, and your severance pay is worked out by your years of service. I'm not sure if I understood that correctly though.
Yeah, so Nuran, the way I understand it is you can always improve on the severance pay. So in other words, you can move from 1 week to 2 weeks for every year completed year of service, but no, you can't say, well, this replaces notice. I mean, notice is still notice.
Yeah.
And then I think CT, we've asked to answer your question, review bumping requirements versus LIFO. We've answered that. Just to see if we've missed anybody. No, I think we've covered everything.
I think so.
All right. Thank you very much, everybody. That concludes our session. Thank you very much to Gretchen.
Thank you.
It was very, very informative. Thank you very much. And we'll make available information after the webinar as well. Thank you very much for your participation.
Thank you, guys.